21, otherwise known as the Triennial Review. Today is day 5, and I'm going to ask the Commission's administrator to do some housekeeping first.
Yes, sir. Good morning. You're referring to the roll call, correct?
Yes.
Okay. Good morning, commissioners. Let me start with Commissioner Candelaria. Are you present? Commissioner Certain?
I'm here.
Commissioner Dominguez?
Present.
Commissioner McWilliams? Commissioner Modi?
Present.
Commissioner Musharafi? Commissioner Patton?
Here.
Commissioner Rader? Commissioner Cipher?
Here.
Commissioner Thompson?
I'm here.
Commissioner Timmons? Commissioner Vigil?
Here.
Vice Chair Wade?
Here.
Chair Stringer?
I'm here.
Let me go back to Commissioner McWilliams, if you've joined us. Or Commissioner Musharafi. Commissioner Rader. Or Commissioner Timmons. Mr. Hearing Officer, Chair Stringer, we have a quorum.
Thank you. At this time, I'd like to give Council Sanchez an opportunity to address any preliminary matters.
Good morning, Hearing Officer Shakalan. Thank you for the courtesy. I don't have any other than I assume you're going to allow for public comment, as has become the practice in the last several days, and then proceed with the witnesses. And I would just mention to Chair Stringer that there is no need for her to reconvene the meeting in which the Triennial Review hearing is occurring. She can do that after you conclude the hearing and close the record, and then she can proceed with the remaining agenda items. Thank you, sir.
You're welcome. Ms. Jones, would you like to make an announcement to the public?
Yes, sir. I have not received any emails or chats from members of the public, but should some sign on and participate, the practice has been to send me a chat alerting me to the fact that you'd like to speak, and then I will alert the hearing officer, who at the appropriate time will allow some time for comment.
Chair Stringer, is there any preliminary matter that you would like to deal with before we get started?
No, sir, but thank you for the opportunity.
Parties, are there any preliminary matters that we need to deal with before we continue taking testimony from, I think, Amigos Bravos and Dr. Khan on issue number 7?
Yes, Mr. Hearing Officer.
Ms. McCallum?
Good morning. Mr. Hearing Officer, San Juan Water Commission's witness, Ms. Jane DeRose Bamman, would like to request the opportunity to correct or clarify one of her responses to a question asked by Mr. Verheuvel on cross-examination concerning topic number 5.
Okay, we'll get to that in just a bit. Let's finish topic 7, and then we can come back to that. But I think Mr. Rose Bamman is also scheduled on topic 7. Do you agree?
No, sir. The San Juan Water Commission has withdrawn its objections on those matters.
Thank you for reminding me that.
Yes, sir.
Okay, we will deal with that between 7 and 8 if that works for you.
Thank you very much.
Any
Mr.
other
Hearing Officer?
Yes, Ms. Jones.
Pardon me. We do have one member of the public who has just signed on and would like to make a a comment.
Okay, we'll get to that in just a moment. Let's
Okay.
finish with preliminary matters with the parties. Are there any other parties that have preliminary matters before we take this public comment and start with testimony? Okay. Pam, would you ask the public member to engage?
Certainly. Mr. Logan Glassnap, if you could unmute and turn your camera on, please. You're up.
Great. Madam Chair and Commissioners and Ms. Jones, thank you very much for the opportunity.
Before you start, sir, you're going to be sworn in.
Great, thank you.
Would you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
Will you
Okay.
state and spell your full name, please?
Yeah, absolutely. It's Logan Glassnap, Glasenapp. First name is Logan.
Thank you.
Mr. Glassnap, you have up to 5 minutes to make a general comment.
Great. Thank you very much for the opportunity to provide this comment this morning. As I said, my name is Logan Glassnap. I'm the staff attorney for New Mexico Wild. We are a 501c3 nonprofit organization committed to protecting New Mexico's wild lands, waters, and wildlife. I'd like to first actually apologize for any time that may have been wasted Friday evening waiting for me to provide this testimony. But I will intend to make this brief to not waste too much more of the time of the commissioners. New Mexico Wild urges the commission to adopt a definition of climate change that identifies human activities as the major cause of climate change, and to specify that combating climate change as a purpose of the regulations. As we've seen just this year, unprecedented wildfires across the West, flooding in Germany and China, and wildly inconsistent weather patterns around the globe all show that time is running out for us to act and to avoid the worst impacts of climate change. Simply acknowledging humanity's contribution to that climate change is a small but essential first step. New Mexico Wild also supports the adoption of a contaminants of emerging concern definition that clearly gives the Environment Department the authority it needs to require monitoring of these harmful materials. We support adding PFAS to this CEC definition. In fact, we really need look no further than the pecan orchards of southern New Mexico and their use of PFAS as an example of the critical need to address the growing health impacts, particularly visited upon children, of emerging contaminants. New Mexico Wild opposes an effort to weaken the human health organism-only criteria for toxic pollutants. As the commissioners likely know, New Mexicans rely on healthy rivers, streams, reservoirs, and lakes for both sustenance and recreation. And finally, New Mexico Wild opposes the proposal to limit monitoring of operations at the Los Alamos National Laboratories to an outdated EPA list of monitoring methods. Simply put, New Mexico cannot cede control of its own environmental future. Thank you for your time and patience, of course, Madam Chair and Commissioners, and that is the conclusion of my comment.
Thank you, Mr. Glassnap. It is my understanding that we have another member of the public that would like to make a comment.
Yes, sir. I'd like to call Kathy Swedlin, please.
Morning, I'm Kathy.
Would you raise your right? I do not hear you if you're speaking.
My name's Kathy Sweet.
I do not see her.
Ms. Swedlin, when you get your microphone working, we'll come back to you. There you are. Let's see if we can hear you.
Can you hear me now?
Say something.
I'm Kathy Sweetland.
Okay, go ahead and swear her in again.
Okay.
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Would you state and spell your
Miss-
full name, please?
Kathy Sweetland.
And spell it, please.
CATHYSWEDLUND.
Thank you.
Ms. Sweetland, you have up to 5 minutes to make a general comment.
NVD Triennial. Yeah, I saw the email come out, so I want to.
Mr. Peacock, would you mute your microphone, please? Go ahead, Ms. Sweetland.
Thank you very much for this time today. I just recently became aware of this meeting, and I feel very, very compelled to speak to the importance of protection of water, air, and earth. We are in a crisis with the climate, as is evidenced by raging fires and flooding around the planet. And it is, to me, obviously human caused. And to take away any kind of ability to enforce change in our carbon footprint would be unconscionable. We really have to do as much as we possibly can to prevent the demise of our planet. And so I strongly encourage that we stand firm on this identification of climate crisis as human caused. I also wouldn't put any limits on protections of the environment when we know that so many people are suffering from contaminated water and very few people have clean, healthy water to drink. We have to have the strictest standards regarding contaminants. There's epidemic cancer. There's so many chemicals in our environment. We know that there's chemicals in our bodies because of what we're doing to our environment. And the fact that there's toxic fish is just heartbreaking. My goodness, people need to be able to fish to eat. And if we're talking about standards of contaminants in fish, there should be zero contaminants in our waters. As far as limiting monitoring for Los Alamos National Labs, that lab is contaminated, and it has been contaminated for years and years. I grew up next to Rocky Flats up in Colorado that was producing plutonium pits, and my whole family has experienced cancer, including myself. And now I'm downwind of Los Alamos. And the fact that they're bringing in more uranium and increasing the pit production, and you would want to limit the monitoring of that, especially for all the indigenous people that live near the lab. This is unbelievable that this is a possibility to me. We have to stand strong and be firm in our protection for our grandchildren, our children, all the animals that are suffering from what we're doing and our practices. We're very selfish in our lifestyle and privileged and causing a lot of harm. And I really appreciate that you're having this meeting and discussing this. And I hope that you can hear me clearly. Thank you.
Thank you. Let us proceed Unless, Ms. Jones, there are any other members of the public?
There are not.
Thank you. Let me know if there are through the chat. Ms. Jones,
Yes, I will do that.
thank you. Ms. Fox, are you ready to proceed? Please.
Yes, thank you, Mr. Hearing Officer. Good morning, Mr. Hearing Officer. Good morning, Madam Chair and members of the commission. Ms. Khan, who is, although she is incredibly knowledgeable, she is not a doctor. Ms. Khan will now give her final PowerPoint presentation on Lannel Waters.
Great, Mr. Hearing Officer, Madam Chair, members of the commission, let me start sharing as I've done on my previous topics. Let's see. Is that working for you all? Great, I see a nod. Thank you for this opportunity to testify. I think this is my final time in front of you all as part of this proceeding, and I thank you for your patience and attention over this multi-day hearing. This is reminding everyone we're still on topic 7, which was the topic of waters on Los Alamos National Laboratory, and specifically the focus of my testimony is on the segments 128 and 140. In summary, Amigos Bravos supports moving the three Lannel waters from segment 128, which have lesser protections for non-perennial waters, into a new segment 140, which has increased protections for non-perennial waters. And this is so we support NMED's proposal to move those 3 waters into segment 140. In addition, in the near future, Amigos Bravos supports assigning segment 140 with the increased protections. And specifically when we're talking about the difference between 128 and 140, we're talking about 128 only has chronic aquatic life criteria protections, and segment 140, segment 128 only has acute chronic, let me start over. Segment 128 only has acute aquatic life criteria. Segment 140 has both acute and chronic, and that's a substantial increase of protections for the aquatic life and the appropriate protections in our view for intermittent waters. And in the near future, Amigos Bravos supports assigning segment 140 as the default protection. Right now, segment 128 in the current standards is the default protection for all non-perennial waters on Lannel property. We think that this is reversed for what it should be, which is that 140 should be the default and water should only be placed into segment 128 once they've been affirmatively identified as ephemeral. That is the way that all other protections are applied to all other non-perennial waters in the state. So waters are assumed to be the intermittent protections, which include both the chronic and acute criteria, until they are affirmatively keyed out and there's a use attainability analysis that determines that they're ephemeral. And so we think that approach should also be applied to Lannel waters. And this was NMED's original proposal in the August 2020 petition. And we thought that was the best approach moving for protections for these waters. I thought it would be useful to give a little bit of a history of what has happened with these segment 128 waters. So, and originally, so this goes back to the 2005 Triennial Review, which I attended. I've actually attended the past. This is my 4th Triennial Review participating in. And so I was at the 2005 and the 2009 and then the 2013, 2014 Triennial Review. And these segments were at issue specifically in the 2005 Triennial Review, as well as in the 2013-2014 Triennial Review. So in the 2005 Triennial Review, NMED proposed a new statewide intermittent segment, which ultimately became our current segment 98. That's the unclassified intermittent segment in our standards. At the same time, the NMED proposed a new LANL intermittent segment, which is now segment 128. NMED originally proposed back in 2005 to give non-Clean Water Act 101A uses of limited aquatic life and secondary contact to both of these segments. You all, this body, the WQCC, determined during that 2005 hearing that intermittent waters can support the Clean Water Act 101A2 uses of marginal warm water aquatic life and primary contact, and applied these uses to segment 98. So they gave those increased protections to segment 98, but they did not apply these, they did not carry over that logic and those protections to segment 128, even though the same information was relied upon during that hearing to assign those designated uses to each of those segments. Then EPA, when it was sent to EPA after the 2005 Triennial Review for approval, EPA did not approve segment 128 because a use attainability had not been prepared to justify applying non-101A uses to these LANL waters. NMED then prepared a UAA, and after the fact, UAA, to justify a decision that had already been made. This use attainability analysis was faulty because it erroneously presumed that fish had to be present to apply 101A2 uses, even though the Clean Water Act clearly only requires the presence of macroinvertebrates. Then, during the 2013-2014 Triennial Review, Amigos Bravos proposed to apply the same level of protections to LANL intermittent waters that apply to all other waters in the state. As a result of that proposal, we entered into a stipulated agreement with LANL and NMED to further examine these waters. And that's the process that we've been undertaking for the past, I guess it's 6 years now, where we've been going out and performing the hydrology protocol and examining these segment 128 waters. And those hydrology protocols, there have been 47 that were conducted jointly by NMED and LANL. And in some instances, Amigos Bravos was also present. Of the 47, 5 stream segments keyed out to perennial and 21 keyed out as intermittent. And macroinvertebrates were found in at least 11 of the 47. But yet, what we're getting is, in this proposal, is only an upgrade of 3 segments, which represent actually 6 of the hydrology protocols were covered. The 3 segments that are being upgraded. And we're pretty disappointed that LANL only concurred with upgrading these 3 streams. And now we've seen from the testimony that that's been reduced to supporting only the upgrading of 2 streams. And while we have clear information that has shown that we have, many intermittent waters, 21 intermittent waters, that are currently being protected with these less protective standards in segment 128. Here. So in conclusion, we think it's appropriate. We think the data supports protecting the 3 waters proposed by NMED under segment 140. Those segments are Effluent Canyon, S-Site Canyon, and 2 Mile Canyon. In addition, in the near future, other intermittent waters should be considered by the Commission for protection under segment 140. And I will also like to point the Commission to our Exhibit 16, Amigos Bravos Exhibit 16, which is the summary of those hydrology protocols and which ones keyed out to intermittent and which ones keyed out to perennial and which ones keyed out to ephemeral. So if looking at Exhibit 16 will give the commission a sense of all the other waters that are currently protected in segment 128, which we feel are inappropriately protected and not protected enough. And with that, that concludes my testimony on this issue.
And do I understand it correctly that that concludes your testimony for the rest of this proceeding?
That is correct.
Okay. Ms. Fox, before we ask for cross-examination from parties, are there any other witnesses that Amigos Bravos has on this topic?
No, Mr. Hearing Officer, that concludes our case.
In total, concludes your case?
With all our witnesses, yes.
Perfect, thank you. Okay, are there any parties that wish to cross-examine Ms. Khan on this topic? Mr. Rose and Mr. Verheuel, and hold on a second, I saw Ms. McIntosh as well. Mr. Rose and Ms. McIntosh? No, you're shaking your head, Ms. McIntosh. What do you mean? I can't hear you, Ms. McIntosh.
Mr. Hearing Officer, we had our lines crossed. I think Ms. McIntosh will do the cross-examination. Thank you.
Okay. Oh, okay. So Ms. McIntosh will do the cross-examination first because Mr. Rose raised his hand first, but really that's for Ms. McIntosh. And then Mr. Verheuel, and I don't see any of the parties wishing to cross-examine. So Ms. McIntosh, please proceed.
Thank you, Mr. Hearing Officer. Can you hear me now?
Yes, perfectly.
Very good. Good morning, Ms. Khan. I only have a few questions. In your testimony and demonstrative exhibit, you indicated that 5 segments keyed out as perennial. Is that correct?
We can't hear you, Ms. Khan.
Sorry about that. I didn't think I had pressed mute, but yes, that is correct.
And were those 5 segments, are those 5 segments currently classified as segment 128 waters?
They are currently not in segment 126. So that those are 2 of those waters, I think, are of those 5 are the waters that question that that are part of LANL's proposal to add to 126. In terms of where they I think I understand your question is where they currently are protected now.
Yeah.
Okay, that is, we have not taken a position on that. While we agree that the waters that LANL has proposed for 126 are perennial, we have no position at this time on whether they should be protected under segment 126 or whether they are protected under segment 99. We may take a position during our post-hearing brief after a review of the case by both NMED and LANL. What we think is critical is that these waters, that these perennial waters that have been identified should receive chronic life protections, chronic aquatic life protections. And both NMED and LANL's approach does that, at least for those 2 waters that were identified by LANL in their proposed changes.
Let me break down your response just a little bit. The 5 segments that keyed out as perennial, were they evaluated by HP, by hydrology protocol surveys, consistent or under the joint stipulated agreement?
Yes, it was part of the process that we all undertook.
And would you agree that one of the purposes of the joint stipulated agreement was to identify segments of LANL waters that could be subject to increased protection?
Yes.
And that of those segments that keyed out as perennial, if they were classified as under 126, that increased protections would be afforded by making that adjustment?
Yeah, so I think that the process, I think the commission, we've heard a lot of testimony on this, and I think that there's two different approaches being taken. The one by NMED is that yes, these waters weren't identified as perennial. We didn't know they were perennial, but because we've now identified them as perennial, NMED's position is that they are by default protected under 99 because of the specific language of 128 talks about ephemeral and intermittent waters at LANL. I understand LANL's perspective as well, which is that all the waters were previously classified on LANL property, and if they weren't specifically identified in 126, they were identified in 128. So I understand the two approaches that are being taken by NMED and by LANL. We haven't taken a position on that. I don't. As I mentioned, is that what we think is critical is that these waters receive the proper aquatic life protections, the chronic life protections. Both NMED and LANL's proposal do that, and so we think that and that is good, and we support that.
So my question really was simpler. By affording protection under 126, if that is ultimately what the commission adopts, that would achieve the joint stipulated agreement, at least one of the joint stipulated agreement objectives of increasing aquatic life protection for those segments that are being that keyed out as perennial and are currently proposed for additional protection. Is that correct?
Yes, both LANL's and NMED's approach would achieve the goals of the stipulated agreement.
Have you, shifting gears just a bit to segment 140 waters, those segments that are under consideration for 140, have you had the opportunity to review the data that was presented in LANL's rebuttal testimony regarding Effluent Canyon?
I did a quick overview of that, but not a detailed review of that Effluent Canyon data. So yes, a quick overview is the answer.
And do you understand that DO and pH do not meet 140 criteria?
Yes, I do understand that that there are some instances where the water quality isn't at the level of protections assigned to 140, the proposed 140. Yet that doesn't mean that waters can't be, that doesn't mean that it isn't attainable, that those waters aren't attainable. In fact, the rebuttable presumption is that waters will be able to obtain those 101A2 uses. And in addition, there could be discharges in terms of the continued implementation of some of the controls that are planned and are being implemented continuously at LANL under permits such as the individual stormwater permit could result in those criteria ultimately being attained.
At this time, however, there's no data other than the water quality data presented by LANL, as far as you're aware. Is that correct?
That's
for
correct.
Effluent Canyon. Regarding the history testimony, did EPA accept New Mexico's proposal for segment 98 waters after the 2005 triennial review?
Yes. That they
And
accept, yeah. Sorry.
Are you aware that the Water Quality Control Commission took, quote, after the fact, close quote, action on the 98 waters?
I believe that they took the after the fact action on 97 waters. That's my memory of that, is that EPA required that if waters were going to be moved from 98 to 97, there had to be a use attainability analysis applied that to move those waters into from segment 98 as the default into segment 97, which is the ephemeral protections.
Mr. Hearing Officer, I have no further questions.
Mr. Verheuel?
Thank you, Mr. Hearing Officer. Good morning, Ms. Khan. I just want to clarify something. Your demonstrative exhibit and your verbal testimony referred to I think the most recent triennial review as having taken place in 2013 and 2014. My recollection is that hearing was held in October of 2015. Is that your recollection?
I have it in, the dates of the hearings blend together because the process is a multi-year process. In fact, I often say it's called the triennial review because it takes at least 3 years to do it. And then we have another 3 years. So you could very well be right. And I was looking at the documentation from earlier in the process. I believe it started in 2013. And I will take your word for it I could go back and look if you want me to confirm.
Well, I actually would, because I think it's pertinent to the amount of time. If you could look at NMED Exhibit 72, if I could direct you to that. Okay. And I'll tell you why I think it's pertinent and why this question is important, because your testimony talked about the joint stipulation that the three parties entered into and the amount of time that's been spent.
Well, I could go back and look at the stipulated agreement to open
That's exactly what NMED Exhibit 72 is.
Oh, it is. Okay.
Yeah.
It may take me a while. Do you have it in front of you?
I do.
Do you want to share your screen?
Oh,
no.
Actually, I'd rather not.
Okay. That's great. I will find it. It's just going to take me a while to get to exhibit.
If you have the stipulated agreement somewhere more handy, you can look at that.
Okay, I do have it more handy, but that still will take a minute.
Okay.
I am willing to concede to your dates, though, if that is helpful in terms of our time.
I appreciate that. Do you have it up in front of you now?
I don't.
All right.
I want to just concede that you are right with your dates. I assume that you have the stipulated agreement in front of you and it was signed in 2015. And
I do, and I didn't mean to make this more laborious than it had to be. So I'm sorry with that. I have no further questions for this witness on this topic.
Thank you.
Are there any cross-examination questions for this witness from commissioners?
Mr. Hearing Officer, this is Commissioner Thompson.
Yes, Commissioner Thompson.
Good morning, Ms. Khan. Thank you. You stated that streams that are subject to protection under Part 128 aquatic life receives acute protection, whereas streams under Part 140 receive both protection for acute and chronic constituents. I was not aware of that, and I was wondering if you could point to where that specification is stated in the proposed standards.
Commissioner Thompson, I'd be happy to. It is in the difference between what designated use is applied to those segments. So segment 128 has the limited aquatic life use, and segment 140, I believe, has the marginal warm water aquatic life use. And if you go to segment 900 in the standards at the end where before the table, I believe it's still 900, I can pull it up. It has each of the designated uses and the criteria that apply to those uses. And so, so in the current standards under 900, it will list, like aquatic life, high quality cold water, limited aquatic life, marginal cold water, marginal water, all of those aquatic life subcategories, and it will have the specific criteria that apply to each of those designated uses.
Okay, I think I have found it. Thank you very much. I have no other questions.
Are there any other commissioners? Are there any members of the public that would wish to cross-examine Ms. Khan? Ms. Fox, do you have any follow-up that is directly related to the questions that were asked?
I do not, Mr. Hearing Officer. Thank you.
May this witness be excused? Thank you, Ms. Khan, for all of your hard work.
She's not.
Okay, the next party we have, we do not have San Juan. We have already taken a witness named Fulton on this matter. I don't think there are any parties that have anything left on topic 7. Is that correct?
Mr. Hearing Officer, this is Lewis Rose. No, but one question I had for you is that I think a number of the documents that were referred to by the various witnesses concerning the commission's actions in 2005 in setting up the Lano Waters, I think are in evidence, and there's certainly been references to a number of things. What I don't know is whether all of those exhibits are a complete record of the commission's decision and correspondence in response to EPA, and just to make sure that you and the commissioners have access to all of that documents if we didn't have a complete set. We're just asking that the commission take administrative notice of its proceedings, both in 2005 and in response to that, ultimately on the 2007 UAA as well.
So, Mr. Rose, let's be very specific about what documents you are referring to, because I'm going to make a list of them. So would you start from the oldest document and work forward?
I don't have the dates, Mr. Hearing Officer, but when the commission adopted both the section 98 and 99 waters, I believe, and the Lano waters was originally decided in 2005 as part of the 2003 Triennial Review. The commission's decision is referenced. I think it has reasons and an order that codifies the commission decision and changes to the rules. My understanding was that was then submitted to EPA for approval. EPA reserved a decision on the Lano Waters piece, and my recollection was that EPA disapproved the commission's original sort of default, and the commission then amended its position and divided the defaults in 98 and 99 between ephemeral and intermittent. They were both combined, is my recollection of the original commission decision. The commission would have acted, there would have been a reason statement for that decision and a submittal to EPA for approval, which they ultimately did, as well as a UAA that's been referenced. It's a use sustainability analysis that I believe is part of this record, but that's been referred to a number of times. That went to EPA, which ultimately approved secondary contact for the Lano waters, which are currently in Part 126 and 128. So those were the documents that I was specifically referring to. I mean, my understanding is some of them are in the record. I just don't know if it's a complete set or not.
Okay, so let me make sure I understand before I go to the parties. This request, or I mean, is this an objection, or is this, what is this really?
This is just a request that the commission that you or the commission take administrative notice of the 2003 Triennial Review proceedings through discussions with EPA and EPA's final approval of the changes made to the state's water quality standards.
So when you say 2003, before you said 2005, is that because it spanned those years?
That's correct. In fact, wasn't complete until the UAA was submitted in 2007. So I think, as Ms. Khan pointed out, these are multi-year operations, unfortunately.
Okay, so let me go first to Ms. Fox. Ms. Fox, what do you have to say about this request?
Thank you, Mr. Hearing Officer. I don't know what documents Mr. Rose is referring to that you should take administrative notice of in terms of the record. And so I think we would need clarification on that. I do think that documents from a prior proceeding, which would include transcripts, exhibits, should have been submitted as exhibits in this proceeding. It strikes me that any triennial review is going to be, the hearing proper itself is going to be a massive record, and proceedings, before or after, pleadings is going to be massive as well. And so I'm not even sure what the request is, so I guess I object.
So let me see if I can, before I go to you, Mr. Verheuel, when I will, Mr. Rose, your request stems from testimony given by Ms. Khan, is that right?
In part, yes.
In part. Well, what is the other part, so I can make sure I understand?
The other part was, I haven't been able to verify whether the documents that are currently in the record represent the entirety of the discussions with EPA and EPA's decision. And so I want to make sure that if the commission is inclined to review testimony on the commission's 2003 triennial review and the results of that they have access to all of those records, as opposed to the records that the various parties may have submitted in this context. I'm not sure whether you have the entire record in front of you. I just want to make sure that you have access to the entire record when you review what was actually done by the commission in 2005, and then subsequently in response to EPA's record of decisions on approval or disapproval of those standards.
Well, before I go to Mr. Verheuel, only relevant evidence is allowed into this hearing. Why do you believe it's relevant what the commission did in 2003 to 2007, or what the EPA did at that time?
Mr. Hearing Officer, I believe it's relevant, one, because you've heard testimony concerning what the commission did and in the 2003, when it first established both the 98 and 99 requirements, as well as the 126 and 128 provisions. And so the question of, and there is a debate, and you've heard that too, concerning Lano's interpretation of the Lano Waters provision and the department's review of the same record, reaching different conclusions. And so, and that's relevant because there's a debate in this triennial, and you've heard this, I think, not just in this hearing, but in the pre-hearings, about what the effect of that decision is to those waters, which as a result of the hydrology protocol may have or could be perennial waters, and whether or not, under the department's view, they defaulted to, I think it's part 99, and in Lano's view, they're still within section 128. And the difference is what action, if any, the commission needs to take to ultimately include those in section 126. So what the commission did and EPA approved is, I think, relevant to what the commission has been asked to do and which course of action is actually the more appropriate in terms of reclassifying, in our words, those waters from intermittent or ephemeral to perennial.
Before I go to you, Ms. Fox, I still have to hear from Mr. Verheuel, but Mr. Rose, I think the argument you're making is that since it was testified to today and there was no objection as to relevance, that what the commission did and what the EPA did several triennial reviews ago is now somehow relevant to what the commission should do now. Is that the argument?
In part, Mr. Hearing Officer, and Lano witnesses testified as to what happened during that triennial, as the department, in terms of how it construes what needs to happen next to the waters I think we've identified now as perennial.
Right.
So I think both in terms of the department's testimony, Lano's witnesses' testimony, and today with Ms. Kahn's testimony, yes, that's the relevant consideration.
Mr. Verheuel?
Yes, thank you, Mr. Hearing Officer. This seems very simple to me. As Mr. Rose just said, multiple parties have provided testimony and supporting exhibits with respect to what this commission did at the triennial review that was held in the 2003 to 2005 timeframe. Mr. Rose appears to not be certain if he has filed all the evidence that he needs to in order to support his client's position. And so now he's trying to ask the commission or yourself really to take administrative notice of those records in order to get another shot at making sure that the right exhibits are in evidence. And I would say every party had full and fair opportunity during NOI, during submission of rebuttal testimony, and then at the hearing itself with exhibits submitted during the hearing to submit such exhibits that support their position. And for that reason, you should deny Mr. Rose's request.
And Ms. Fox, did you have anything else to say?
Thank you, Mr. Hearing Officer. I concur in everything that Mr. Verheuel just said, and would also add that Ms. Kahn's testimony that she gave today was in our rebuttal testimony, and so Lano has had full opportunity to respond to that during this hearing. And this issue about the Lano waters has been before the in this proceeding since NMED filed its amended petition. And so Lano has had full opportunity through filing direct, through filing rebuttal exhibits and SIR exhibits to put any additional evidence in the record. And so I object. It's too late to submit new evidence that doesn't even have a witness for in support. And the issue here is not relevance. The issue is, he's out of time.
And Mr. Hearing Officer, might I respond?
Yes, Mr. Rose.
I'm comfortable with Lano's exhibits, and what I'm trying to seek before the commission is to make sure the commission's comfortable that it has all the information that's relevant to its review of what happened and its decision. If the commission decides it has everything in front of them as exhibits, that's fine. If it wants to seek something more based on the arguments of parties as to what this commission actually did in 2005 and 2007, and the commission would have the ability to do that. And so I think the commission ought to be free to look at its prior records and its prior proceedings to determine what the most appropriate action is. And I don't think they should be limited or to just what the parties have submitted in front of them in a rulemaking petition, which is the intent of which is to set state policy on protection of these waters. So I think the commission ought to be able to look at all of its prior proceedings in deciding sort of not just this proceeding and all subsequent proceedings as well. And particularly when we have none of the commissioners, except perhaps Commissioner Dominguez, was actually on the commission at the time. And so I think it's even more important that the commission have access to all of those records. I think it may be that the parties have submitted complete records and you have everything in front of you. I just want to make sure that if there's something we didn't include, that you're not hamstrung in going back and looking at that record. But I'm comfortable with what we've submitted in supporting our case. So
Okay. I think Commissioner Vigil might have also been a participant in that triennial review as well. But that being said, at this time, Mr. Rose, I'm going to deny your request, and
Okay.
we're going to move on. I think we're moving on to number 8 now. So if I'm correct, and Mr. Verhule, I'm sure you'll let me know, I think we're going to kick off with formatting and grammatical corrections to the rule through your witnesses.
Mr. Hearing Officer,
Yes,
Jolene
Ms. McCaleb.
McCaleb.
Yes.
You had indicated that you would consider the request of Ms. DeRose Bamman to clarify her testimony on topic 5.
Thank you. Yes, let's do that now.
And Mr. Hearing Officer, I would just
Yes,
note
Ms.
at this
Beck.
point that NMED does object to Ms. DeRose Bamman correcting testimony that she gave on topic 5. The opportunity to do that would have been on redirect. That did not occur. She had the opportunity to file testimony, be cross-examined, give redirect. We've moved on at this point, and this is not something that people generally are afforded the opportunity to do. So I wouldn't expect that you would extend this opportunity to any other party as well.
I would if there was no objection to doing so, but you've made an objection, so let's hear from Ms. McCaleb.
Thank you, Mr. Hearing Officer. This is an issue that Ms. DeRose Bamman brought to my attention this week, and that she's concerned that one answer that she provided is incorrect if there is not additional context provided for her answer.
And who was the question from that she gave that incomplete answer?
It was from Mr. Verhule.
It was from Mr. Verhule. And what is the reason why she did not give a complete answer at the time?
My understanding, based on my conversation with her, was that she misunderstood the scope of the question and her ability to respond to it.
Well, let's do this the way we would do it at trial. I will allow you to voir dire the witness, and then we will hear any objection, and we will strike it from the record if it turns out that she had an opportunity and didn't take it. So, Mr. Verhule, are you there?
Mr. Hearing Officer, Mr. Verhule had to leave this hearing to go attend something else, which we discussed last Friday when we were scheduling this. So,
So
I will handle this matter in his place.
Wonderful. Ms. McCaleb, what was the question?
The question, I don't recall the exact verbiage of the question, but it was whether she had contacted permittees concerning the primary contact issue.
Let's ask the court reporter if I don't know if you're able to find this question.
It would take me a while.
It would take a while.
Yes.
Well, I'd like to hear the original question and the original answer, Ms. McCaleb, before making a decision, since there is an objection to it. So maybe what we can do is when we take a break, if in fact Ms. Adeguin, how long would it take for you to find the original question and answer?
I really don't know. Depending on how accurate my search would be.
Right. And that's, of course, based on the recitation that Ms. McKellop just gave you. Right.
Right.
Ms. McCallum, in light of the objection from the state, I'm not going to allow clarification to that question. I believe your witness had an opportunity to bring this up at the proper time, and at this point, I think we're going to have to stand with the answer she gave. So I'm sorry. So let's go on to. You're welcome. Let's go on to topic number 8. And Ms. Maxfield, you have witnesses?
Yes, Mr. Hearing Officer, the department is ready to proceed on topic number 8. And the first witness that we recall to the stand will be Chris Barrios. And I will note at this point as well, topic is mostly grammatical and formatting issues, and this will be non-technical testimony.
And short in summary?
And short in summary, I imagine. We have 3 witnesses, but each of them will discuss briefly a very small portion of this.
Please proceed. He's under oath already, and so are all the other witnesses.
Yes, Mr. Hearing Officer. Mr. Barrios, can you briefly describe the department's proposed amendments to the administrative code regarding formatting corrections in sections 311 and 312?
Yes, the department is proposing corrections for spacing between sentences to consistently have 2 spaces throughout 20.6.4 in MAC. And the department is also proposing adding missing basin descriptions in classified sections 20.6.4.311 and 20.6.4.312.
And for those changes, did the department submit written testimony regarding those proposed amendments?
No, the department did not. However, the department did provide reasoning in its statement of reasons filed on March 12th, 2021 for missing spaces and August 19th, 2020 for the missing basin information.
And can you briefly describe the non-technical reasoning behind these proposed amendments?
Yes, the proposed changes ensure consistency with the rest of 20.6.4 in MAC.
Okay, thank you. Now I'm going to direct your attention to a redundant dash that occurs periodically throughout sections 100 to 899, and also a hanging period in section 808. Can you briefly describe the department's proposed amendments regarding these formatting corrections I just directed your attention to?
Yes, the department proposes removing dashes following colons in the basin description for 97 classified sections in 20.6.4.100 through 899 in MAC. The department is also proposing correcting the hanging period between the words to and the on the 3rd line of the section 808 description.
Did the department submit written testimony regarding these proposed amendments you just described?
Yes, in my direct testimony filed as NMED Exhibit 2.
And what's the reasoning behind these proposed amendments?
The proposed change is also consistent with the rest of 20.6.4 in MAC.
All right, I'm now going to direct your attention to the spelling of the word canyon in sections 405 and section 408 and section 97. Can you briefly describe the department's proposed amendments to sections 405 and 408 regarding the spelling of the term canyon?
Yes, the department proposes to correct the spelling of the term canyon in both sections. Referenceable sources, most importantly the USGS 7.5-minute topographic map, identify the water body as Cañón Largo.
Can you briefly describe the department's proposed amendment to 20.6.4.97 regarding the spelling of the term canyon?
The department proposes to correct the pronunciation of the second occurrence of cañón in 20.6.4.97 C1G in MAC. The current spelling of the word cañón in the subsection is not consistent. The second use of the word does not include a tilde over the N representing the Spanish ñ.
Did the department submit written testimony regarding these proposed amendments to the spelling of canyon?
No, the department did not include the proposed amendment in its written testimony.
And was that covered in the initial statement of reasons either?
No, the department did not include that in the statement of reasons either.
Okay, now I'm going to direct your attention to a colon in section 10H. Can you describe the department's proposed grammatical and typographical amendments to section 10H?
Yes, the department proposes to replace the colon in the subsection description with a period.
Did the department cover this topic in the pre-filed written testimony for this proposed amendment?
No, however, the department did provide an explanation in its statement of reasons filed on August 19th, 2020.
And can you describe the reasoning briefly behind this grammatical correction?
The proposed correction is consistent with the rest of 20.6.4 in MAC.
For all of these typographical and grammatical corrections that you have just testified to, did any party object to them?
No.
And do these sorts of minor grammatical amendments that you've discussed require a historical footnote addition to the administrative code section?
No, fortunately not. As filed in NMED Exhibit 54, the State Record Center and Archives informed the department that grammatical corrections such as these do not require amendment notation for the sections.
All of the topics that you have discussed, are they all captured in the department's Exhibit 110?
Yes, they are.
And do you have any proposed revisions to make to 110 based on these topics at this time?
Not at this time.
All right, thank you, Mr. Barrios. I will now call Ms. Fulham to the stand.
Good morning.
Good morning, Ms. Fulham. Continuing on with topic 8, can you briefly describe the department's proposed amendments to sections 10, 12, and 318 regarding references to section 10?
Yes, the department's proposing to amend references to section 10 and several other subsections, including 10F1D and 10H, 12H, and 318.
Could you briefly describe the reasoning behind these proposed amendments?
Based on the proposed amendments to subsections B through D in section 10 regarding the review of standards, the department's proposing to amend references to these sections throughout 20.6.4 NMAC in order to ensure appropriate implementation of water quality standards.
Did any party object to those amendments?
Not directly.
And can you describe the department's proposed amendments to section 97 regarding references to section 15?
The department's proposing to update the reference in section 97 to reflect the proposed changes in section 15, should the commission adopt those changes.
And did any party object to those amendments?
No, not directly. However, if the amendments proposed to section 15 are not approved by the commission, then these amendments are unnecessary.
All right, thank you, Ms. Fulham. That is all the questions that I have for you on this topic. And at this point, I will now call Diana Aranda back to the stand.
Good morning, can you hear me?
Good morning, Ms. Aranda. I can hear you, and I'm going to direct your attention to section 7S 5. Can you briefly describe the department's proposed amendment to section 7S?
I couldn't hear you. I don't know if the reporter could hear you.
Excuse me, I'll need you to repeat that. I did not understand.
Okay, thank you. I'm not sure what was going on with my audio there, but I will say that again. Ms. Aranda, can you briefly describe the department's proposed amendments to section 7S5 regarding the definition of surface waters of the state?
This amendment reformats the existing paragraphs into a list of all surface waters and subparagraphs. The word and ephemeral are added as a stream descriptor, and as the subparagraphs are formed, the words surface waters of the state were removed.
Can you briefly describe the reasoning behind those proposed amendments?
The department proposed to amend the format of the definition surface waters of the state to provide clarity and aid with readability and referencing, as well as adding the clarification that included ephemeral streams and removing redundant language within the subparagraphs.
Did any party object to these proposed amendments?
No.
And are the proposed amendments as currently filed in NMED Exhibit 110 still correct?
Yes.
Okay, now I am going to direct your attention to the topic of anti-degradation in Section 8. Can you briefly describe the department's proposed amendment to Section 8A1 regarding anti-degradation?
The department is proposing to remove the term in-stream water and add the reference to definition to existing uses as found in 20.6.4 and MAC.
Can you briefly describe the reasoning behind those proposed amendments?
Removing the words in-stream water would broaden the language to include all waters of the state, and such that the language does not just include low-tech waters, such as riverine ecosystem, and includes protections of other existing uses for lentic water bodies, such that still waters like lakes and wetlands. Amending the language would clarify that existing uses are protected for all waters and reduce potential misapplication when implementing the anti-degradation policy. As a follow-up to this clarification, the direct reference to the definition of existing use in 20.6.4.7 NMAC was added.
Did any party object to those proposed amendments?
No.
Okay, I'm now going to further ask you some questions about anti-degradation in Section 8. In Section 8A2, did the department propose new language?
The department has revised NMED Exhibit 110 to revert to the language as it exists today. We have withdrawn the proposed amendment.
And did any party object to that amendment that was originally proposed?
Yes, the department agreed with the testimony of the San Juan Water Commission that the proposed language did not provide the clarification intended.
And does NMED Exhibit 110 capture what both NMED and the San Juan Water Commission have currently agreed should be the language in that section?
Yes.
Okay, and now I'm going to direct your attention to some other subsections of Section 8. Can you play the department's proposed amendments to Sections 8A3 and 8A4 regarding anti-degradation?
For 8A3 and 8A4 and MAC, there's a correction to the spelling of an acronym for Outstanding National Resource Waters. So now it stands as ONRW.
And did any party object to those proposed amendments?
No.
And does NMED Exhibit 110 reflect what the department is proposing for those topics?
Sorry. Yes.
Okay, and to continue this discussion of ONRW. In section 9, could you please briefly describe the department's proposed amendments to section 9A regarding outstanding national resource waters?
The department proposed to remove outdated language regarding the guidelines for WQCC regulation hearings and instead provide the specific and appropriate procedural reference to 20.1.6 and
Could you briefly describe the reasoning behind those proposed amendments?
In March 2018, the former guidelines for Water Quality Control Commission regulation hearings were superseded by the adoption of rulemaking procedures for the Water Quality Control Commission in 20.1.6 NMAC. This section now reflects the correct references for rulemaking procedures before the Commission.
And did any party object to these amendments?
No.
Okay, I'm going to turn your attention to sections 12G and 900I concerning compliance with water quality standards. Could you briefly describe the department's proposed amendments to both section 12G and 900I regarding the addition of the definition of hardness?
The department proposed to remove the word dissolve before the word hardness.
Can you briefly describe the reasoning behind those proposed amendments?
The department has adopted the San Juan Water Commission's proposed changes and removed the word dissolve before the word hardness in 12F and 900I and MAC.
And with that updated language and the San Juan Water Commission's proposed change being adopted, does any party object to those proposed amendments?
No.
Okay, I will now turn your attention to publication references in section 900. Can you briefly describe the department's proposed amendments to section 901? I'm sorry, I said 900 earlier. 901.
The amendments include reference additions, updates to current reference, syntax corrections, and removals of obsolete reference documents.
And can you briefly describe the reasoning behind those proposed amendments?
The reference needed to be consistent with the most current versions of the documents listed.
Did you provide direct testimony regarding this amendment? Direct written testimony, that is?
No, I did not. This section was not discussed in my direct testimony. This was a publication error. However, this amendment was published in the Statement of Reasons for Proposed Amendments to 20.6.4 NMAC as filed last August.
And did any party object to these proposed amendments to section 900?
No.
And given the proposed amendments that you've discussed, do you at this point have any additional amendments to the language as proposed in NMED Exhibit 110?
I do not.
All right, Mr. Hearing Officer, that concludes my questioning, my direct questioning for this witness on this topic. And I think that concludes all of NMED's direct questioning on in this hearing.
Will they stand as a panel?
They will stand as a panel for cross-examination.
Are there any parties that wish to cross-examine this panel? Mr. DeSalen, go ahead.
Thank you, Mr. Hearing Officer. And first of all, I want to just say that I really appreciate the Environment Department going through these regulations and making these little corrections. But I do have a couple of little issues with the revisions to section 20.6.4.7.s as in surface 5, which is the definition of surface waters of the state. So my questions are directed at Ms. Aranjo, but I promise I will be very brief. First of all, as I understand it, you have added in the first clause of that definition a bunch of Roman numerals that you've inserted between the different items in the list of what surface waters are, lakes and rivers, streams, etc. And I saw that your justification for that was to add clarity. And I would like to suggest and ask you if you would agree with me that adding a bunch of Roman numerals in there really doesn't add any clarity at all to this definition. Would you agree with that?
Hi, good morning. The purpose was to list the types of water bodies. So now we have lakes, rivers, streams, including the ephemeral streams, and so on and so forth. Just so we have them listed and it's very clear what the state protects as a whole.
Okay, I don't see the clarity there, but I do agree with you on adding intermittent and ephemeral. I think that's a good idea. But I'll leave that. And then the next thing I want to ask you about is in the next couple of clauses that are marked 2 and 3. It begins with also means, despite the fact that there was already a period in the previous clause at the end of the previous clause. And I want to suggest to you that that's not very good grammar. And if you would agree with that, I would also ask you if, wouldn't it make sense to begin clause 2 and 3 with the words, the term? So clause 2 reads, the term also means, etc.
Yes, I agree. Thank you.
Okay, thank you. That's all my questions. And for the record, those changes are included in our corrected exhibit number 1.
Okay, thank you. I will
Thank you,
take
Mr.
that.
Rano.
Are there any other parties wishing to cross-examine this panel? Are there any commissioners? Or members of the public? We do have another public commenter. So, Ms. Maxfield, if you are finished with these witnesses, may they be excused?
They may, and I have no redirect, Mr. Hearing Officer.
Ms. Jones, would you ask the public member to present herself?
Yes, Ms. Joni Ahrens, if you would turn your camera on and identify yourself, please.
Good morning.
Ms. Ahrens, you're going to be sworn in, and then you will have up to 5 minutes to make a general comment.
Hi, Cheryl.
Hi, Joni. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. And just for the record, please state and spell your full name.
Yes, Joni, Joni, Ahrens, Arens.
Thank you.
Thank you. Madam Secretary, members of the Commission, Mr. Hearing Officer, thank you for this opportunity to provide public comments. I'm speaking today as Concerned Citizens for Nuclear Safety, or CCNS, a Santa Fe-based non-governmental organization that formed in 1988 to address community concerns about the proposed transportation of radioactive and hazardous waste from Los Alamos National Laboratory to the then proposed waste isolation pilot plant on St. Francis Drive in Santa Fe. Our mission is to protect all living beings and the environment from the effects of radioactive and other hazardous materials now and in the future. CCNS is particularly concerned about the amount of time between the triennial reviews. We cite the EPA Region 6, December 22nd, 2020 comments to NMED regarding the triennial review. And on page 3 of their submittal, they wrote, for future triennial reviews, the EPA recommends that the NMED ensure a hearing that is open to the general public for the purpose of reviewing New Mexico's water quality standards is held every 3 years from the date of the state's prior hearing to review its water quality standards to meet the requirements in Section 303C1 of the Clean Water Act. The purpose of this review is to, at a minimum, identify water quality standard changes necessary to meet the requirements of the Clean Water Act. This includes the requirement in 40 CFR Section 131.20A to re-examining any water body segment with designated uses less than the Clean Water Act Section 101A2 uses to determine if those designations are still appropriate. End of quote. CCNS's experience with the triennial review is that it takes longer than 3 years and sometimes up to 7 years. During this time, these water segments flow through urban and rural communities, by farms and ranches, through wildlife areas, as well as segments designated as outstanding national resource waters. And these segments serve as drinking water for communities. The permittees benefit from these delays. New Mexicans suffer from the delays because the most protective water quality standards are not debated in a timely manner. So CCNS respectfully requests or suggests that the Commission, when it approves its Open Meetings Act annual resolution, generally in March or April of each year, that the New Mexico Environment Department make a presentation to update the Commission about the current status of the triennial review process. We feel that this would hold the agencies accountable and give the public an update on what's happening with the triennial review and hopefully encourage the process moving forward. So CCNS is a member of the Communities for Clean Water, and CCNS fully supports the testimony and concerns by the CCW and the Gila Resources Information Project, with a special emphasis for the Commission to provide the New Mexico Environment Department with the authority to require permittees to monitor and sample toxic pollutants and other emerging contaminants. So thank you very much.
Thank you, Ms. Ahrens. I think we are at the end of the evidentiary part of this public hearing. And so are there any parties that disagree with that? Chair Stringer, there are some rules I need to review on the record before we move on to any housekeeping that you might do. So is this a good time for that?
Yes, it is.
Okay. So this is from 20.1.6.300 B7 at the close of the hearing. Now, it does say that there is an opportunity that the hearing officer may allow a brief closing argument by any person who wishes to make one. Are there any parties that wish to make a brief closing argument? It then says, at the close of the hearing officer shall determine whether to keep the record open for written submittals in accordance with 21-6-304. So first, let's talk about exhibits. The court reporter has been keeping track of all admitted exhibits into evidence. Are there any further issues with exhibits that any party wants to address? Okay. Transcript of proceedings. This is 21-6-303. A verbatim transcript shall be made of the hearing, including deliberations. The cost of the original transcript of the proceeding and of providing a copy for each commission member shall be borne by the petitioner. In this case, I think the petitioner is the department. It then says that any person may obtain a copy of the transcript of a proceeding, period. It shall be obtained directly from the court reporter, and the cost of the transcript shall be paid directly to the source. Counsel Sanchez, is that the way it is done?
Hearing Officer Caden, thank you. Yes, that has been the practice.
I just wanted to make sure. I've heard varying opinions about that, but thank you. It then talks about post-hearing submissions. Now, it's my understanding that the commission has ordered the hearing officer to produce a report and is not going to be deliberating at this time. Is that correct, Chair Stringer?
Yes, that is correct.
Okay. The hearing officer may allow the record to remain open for a reasonable period of time following the conclusion of the hearing for written submissions, and those include, if necessary, additional evidence, comments, and arguments, revised proposed rule language, and proposed statement of reasons. The hearing officer's determination regarding post-hearing submissions shall be announced at the conclusion of the hearing. In considering whether the record will remain open for those purposes, the hearing officer shall consider the reason why the material was not presented during the hearing. Are there any requests from any party to keep the record open for what I just read?
Mr. Hearing Officer, I would, I'm sorry, Mr. Sanchez, I didn't mean to interrupt you.
No, please go ahead.
Mr. Hearing Officer, I was just going to note that a lot of these post-hearing matters were dealt with in the procedural order that you promulgated in November. And so I was imagining that the parties would follow the deadlines as laid out in there, and subject to any new decision that you might make about it at this point in time.
Wonderful. And thank you for your comment. Ms. McCaleb?
Mr. Hearing Officer, I was going to make the same point.
Okay.
As Ms. Maxfield, and also note that historically with the Triennial review, the parties have filed post-hearing closing arguments and proposed statements of reasons.
Thank you, Ms. McCaleb and Ms. Maxfield. We're going to get to all that, but I still want to go through the rule because I feel like this is the first one Triennial for me, and I don't want to miss anything. So, okay.
Understood, Mr. Hearing Officer. That's a great idea.
And Counsel Sanchez, what did you want to say?
Just for the record, Mrs. Maxfield's reference to the procedural order is to the one entered on November the 9th, 2020. And just, I have a matter that probably needs to be addressed while we're still on the record. You can decide, I can tell you what that's about briefly, or you can decide when you allow me that opportunity.
Okay, let's wait until I finish going through these post-hearing rules and review the order, and then we'll come back to you, okay?
Thank you, sir.
Okay. Hearing officer report. If the commission directs, and it has, the hearing officer shall file a report of the hearing. The report shall identify the issues addressed at the hearing, identify the parties' final proposals, and the evidence supporting or opposing those proposals, including discussion or recommendations as requested by the commission, and shall be filed with the commission administrator within a time specified by the commission. The commission's administrator shall promptly notify each party of the hearing officer's report has been filed and shall provide a copy of the report along with notice of any deadline set for comments on that report. Now, let's go to the procedural order that was filed November 9. And I am looking at this is the last page, page 5 of the order. It starts out by saying in paragraph 12, in all other respects, the Commission's rulemaking procedures at 20.1.6 NMAC shall apply to this proceeding. It talks about a period of 45 days after notice of the Commission's receipt of the hearing transcript is the deadline to file proposed statement of reasons and closing argument. Ms. Adeguin, how long do you anticipate before you will be filing the transcript in this matter?
I will say 30 days.
That sounds reasonable. Okay. 30 days from July 21st is about August 21st. Add 6 weeks to that, and we come out in the beginning of October. So we're looking at early October for this deadline for the parties to file their post-hearing submission. Now, this triennial has been organized by issue, and the issues have all been broken down by the rule. So I am requesting at this time that any party that files a post-hearing submission, that you use the outline that was created in the Excel spreadsheet to address your statement of reasons and your closing argument and any evidence supporting your statement of reasons and closing argument. At the end of that period, so in early October when that 45-day period closes, this order gives the hearing officer 45 days to produce a draft file of the report and proposed statement of reasons to be served on all parties.
Hearing Officer Shkalin?
Yes.
This is Council Sanchez. My apologies. If I can just briefly go back to the prior deadline. What I'm looking at the table of relevant deadlines, and it references a proposed statement of reasons and closing arguments. I've understood some counsel to also say that they will be submitting legal briefs on certain points of law and perhaps of fact. I don't know if you'd want to clarify that that deadline includes those submissions as well.
I'm glad you brought it up. May I see, okay, so it's your understanding that certain parties are going to be filing legal briefs and what?
I understood there were legal briefs on points of law.
Oh, on points of law.
That
Okay.
it said they would be filing.
Okay. Which parties here intend to file legal briefs on points of law? Okay, I see Mr. Rose, I see Ms. Fox. I see Mr. DeSalen. Okay. Are they all on the same point of law?
Mr. Hearing Officer, I'm not sure what the other parties intend to do, but there were a number of issues raised during the hearing. I don't think we've ultimately decided on exactly what we're going to file yet, And so I would assume we do it as part of our closing argument as opposed to necessarily a separate brief. But at this point, we've identified potentially some issues, but have not decided on exactly what issues to brief yet.
Well, and Ms. Fox and Mr. DeSalen, do you have the same thing to say?
Mr. Hearing Officer, that's exactly right, that generally speaking, the legal arguments are set forth in the closing argument. And so, generally speaking, there's a statement of reasons which sets forth the evidence, and then closing arguments that will make the legal points. And that's how we envision our filing.
Let me hear from Mr. DeSalen. What are you going to be filing?
Thank you, Mr. Hearing Officer. I agree with the points made by Mr. Rose and Ms. Fox. I think we'll be filing closing arguments that will address the various legal issues from the hearing.
Okay, so I want to understand. I want to be further clear about this. The issues in your closing arguments that are legal in nature, do they go to the procedure of the actual hearing, or do they go to the merits of the hearing?
Mr. Hearing Officer, I think that they will mostly go to the merits of the hearing, but I think they could go to both.
Okay.
Mr. Hearing Officer, that would be my understanding as well.
Okay. Well, if they go to whether or not evidence should be admitted or excluded, then I would like to see those legal briefs before I receive the submissions with findings and conclusions. And I would think the 30-day period while the transcript is being produced would be the perfect time to get those in, so I can make some sort of a decision that would then affect the findings and conclusions.
Mr. Hearing Officer, I don't expect that there will be objections to the admission of evidence. Those have already been admitted. I suspect there'll be questions about the weight to be given to various testimony. We'll have arguments about how much weight to give, but not necessarily as to the evidence admissibility.
Okay.
At least unless there are objections raised at the time.
Okay. So far it's been rather vague on what these legal briefs would be pertaining to, so I didn't understand that's what you would be arguing about. So that would be the normal, of course, that would be part of my sorting through the evidence and the parties' closing arguments and statement of reasons. If it involved something other than that, I would want to deal with it before I received these submissions. So Ms. Fox, is that your intention as well?
Mr. Hearing Officer, thank you. At this point in time, we don't have any issues of admissibility, but I don't want to waive on that either. But I hear what you're saying about trying to bring those issues to your attention prior to filing our closing briefs.
So Mr. Rose, back to you. Here in the order, it states that the parties have 45 days to file proposed statement of reasons. Now, I am familiar with finding of facts and conclusions of law, what is statement of reasons?
Mr. Hearing Officer, and the department may have a better sense of this, but by case law, the commission's required to enter reasons for its rulemakings. And I mean, that's been the case by case law since the early 70s. And so rather than findings and conclusions, the court basically asked the commission to explain its decision, to give the court sufficient basis to review it. So they talked in terms of reasons. Some folks doing them as findings and conclusions. And I think if you look at, and we talked about this early on, the format of your decision, and if you look at Ms. Orth's statement of reasons, that is what we're talking about, so that, and not just adoption. For example, if the commission were to adopt a proposal, they would need to explain why they did it, including what evidence they relied on and why they found, if it were contested, why they found certain evidence to be perhaps more probative than other evidence. But it wouldn't necessarily be in sort of the more judicial approach of findings and conclusions. But I think it's really to advise you and to help you draft your statement for the commission, and the commission to meet its obligation under existing case law. And I think the commission's rules sort of accommodate that as well, or at least that's the context of the use of the term reason. But I think, like I said, if you look at what the commission's done in the past, that'll give you a pretty good idea of how they view that playing out.
So the parties are going to submit statements of reasons from their own perspectives, obviously, and each party has, so for example, let's take climate change for a moment here. And we talked about how to define climate change, and each party had a position on that. So when it comes to 20.6.4.6 and 7, D and C, each party will submit a statement of reasons on why the commission should adopt their position regarding the definition of climate change. And what else will they be submitting?
I mean, I assume, Mr. Hearing Officer, they will be citing to the record and give you references as to both whether it's documents filed, exhibits, or the transcript, and so that make your life hopefully a little easier in following the argument. But and if there's a legal question to be raised as to why you should adopt one definition over another, I would assume that would be encompassed in the reason, so that there would be reference to exactly what the basis for the recommendation is.
And when you mentioned legal brief, when Counsel Sanchez mentioned legal briefs, is that the legal arguments that you're talking about?
That coupled with, and others may have a different opinion, I suspect we're going to outline for you our understanding of the statute, the burdens of proof, what the statute means in terms of various, not just definitions, but the commission's obligations, both under federal and state law, to give context to the proposed arguments or statement of reasons in terms of positions. That's what I sort of expect in terms of legal briefs, but looks like Mr. DeSalem may have a different view.
And I'll get to that in just a moment. I'm just thinking about what you said. And when you talk about statute, what statute are you talking about?
Talking about first the Water Quality Act, but also you've heard references to the Federal Clean Water Act and requirements under it. I assume we'll reference federal regs because we have throughout this in terms of what the commission's obligation is or isn't, and we may have a disagreement as to how to construe those. But the commission basically has to look to the Water Quality Act and its requirements for standards, and there's language in the statute about what the commission's responsibility is and in terms of the legislature's delegation. And so by state law, I'd assume that's what we primarily were looking at. I don't recall if there's any other state statute that might be relevant to your consideration, but that's at least what and there's case law construing that statute. And I think I outlined some of it in my opening statement concerning, for example, the commission's obligation for adopting a toxic pollutant definition and prior Court of Appeals decisions in terms of how the court was going to look at this commission's regulation of toxic pollutants. So I assume that that'll be also discussed in whether it's in closing arguments or statement of reasons. I'm not sure yet, but perhaps both.
Okay. Mr.
That's what
DeSalen? Thank you, Mr. Rose. Mr. DeSalen?
Thank you, Mr. Hearing Officer. I just try to focus in and simplify things a little bit. I think what we're talking about here is closing arguments that are written arguments, somewhat similar to a post-trial brief, that kind of lay out narratively what each party's arguments are. And then the statement of reasons, which I would expect is going to be very similar, if not identical, to what would normally be proposed findings of fact and conclusions of law that lay out individual proposed findings and conclusions to support the arguments and that the parties make for the commission to adopt one or another of the proposals. So I don't think it's really anything different from what you are already familiar with in your experience.
Okay. And Ms. Fox?
Mr. Hearing Officer, I concur with what Mr. DeSalen said. It's my experience that in these kinds of very complex proceedings that parties file one document that is findings of fact cited to the record, conclusions of law, and then another document called closing argument where, we sort of get to say our piece in more narrative, argumentative fashion about what we would like, about what we're proposing.
Okay. All right. And Mr. Sanchez, when you brought up this subject, why did you bring it up?
I simply brought it up to make sure that council was aware of what deadline might pertain to those particular pleadings. My concern is only that they have a common understanding as to when those documents are to be submitted under the table of deadlines that you have in your procedural order.
Okay. And it's my understanding.
Let me also, if I could, let me say that I agree with Mr. Rose that the commission does have an obligation under New Mexico case law to state the reasons for its decision. I also concur with counsel that the statement of reasons will look very much like we are accustomed to seeing findings of fact and conclusions of law. But let me clarify that by saying that 20.1.6306 E rather says the commission shall issue its decision on the proposed regulatory change or changes in this case in a suitable format which shall include its reasons for the action taken. That's where we find the genesis for a reference to statement of reasons.
So these legal arguments, Mr. Sanchez, there's no opportunity for a party to reply or respond to any party's legal argument. This is a closing argument and so this is for me to deal with when I am compiling my hearing officer's report, right?
I think that's correct. I don't think they're in the nature of motion practice, rather simply, as Mrs. Fox has correctly stated, statements of legal positions regarding whatever they choose to address.
But since I'm not making a recommended decision, because the commission said at the very beginning of this, we don't need your recommended decision. We just want to see a compilation of everything that is submitted, right?
I have not heard the commission as a body express that preference, but I know that individual commissioners have said that they feel wholly competent to make their own decisions regarding what what changes will be made to the surface water quality standards.
So then I guess what I'm trying to get at is normally these legal arguments that are attached to findings and conclusions, that the hearing officer normally makes a decision on the legal arguments and presents his finding, his or her, but in this case his, finding of facts and proposed final order to the decision maker. But in this case, it sounds to me like the commission also needs to see the legal arguments that parties are making, that the commission adopt one set of reasons over another set of reasons. Is that fair?
Well, as I read the definition of the record proper, those would be included in what is available to the commission.
But I'm specifically talking about my report.
Then I'm a little confused. All right, clearly your report would be submitted directly to the commission, so I'm not sure what you're asking.
And part of this comes from not understanding this part of the process fully and only going by what. Okay, Ms. Fox, good. You're going to help me?
Mr. Hearing Officer, I'm going to try.
Thank you.
What I've seen in the past from hearing officers' reports that do not have recommendations, that the hearing officer will lay out the evidence on, in this case, all sides of the matter, and will also lay out for the body the legal arguments of each party without taking a position.
Perfect. Does any party object to what Ms. Fox just said? Because that makes the most sense to me. I'm not hearing an objection, so wonderful. Okay, Mr. Sanchez, thanks for bringing.
I would just simply say that the contents of your report are guided by 20.1.6305.
Thank you. Okay, then this scheduling order gives me 45 days to put together the hearing officer report. It gives the parties a 30-day period to file exceptions to that report and the draft proposed statement of reasons. And then another 30 days after the receipt of the exceptions for me to file a final report and proposed statement of reasons to the commission for their review and consideration. I believe that covers the post-hearing procedure that I'll be following. So I'm going to turn this back over to Chair Stringer. Ms. Fox.
Mr. Hearing Officer, I have just one question. Either you or Ms. Jones or the court reporter will file the notice of filing the transcript and send that to council?
Ms. Jones will do that, yes. Are there any other questions before we turn this back to Chair Stringer?
Hearing Officer Caitlin, this is Council Sanchez. I had mentioned I wanted to address a matter before we turned the proceeding over to Chair Stringer. One point of clarification. I understand from your comments that you have now closed the record. Is that correct?
I've closed the record insofar as evidence.
Okay. Okay. The matter I wanted to address is Triad DOE in Water Quality Control Commission 2116 or 21-16 filed a petition for rulemaking to amend essentially the surface water quality standards. And in that filing, they filed that on April the 15th, 2021. And in that filing, if I can refer to specific paragraphs in the petition, I'm looking at paragraphs 15, 16, and 17. Essentially, Triad DOE, and I assume that's synonymous with LANL as well, basically said we're filing this petition as a protective petition in the event that our proposed amendments to the surface water quality standards aren't incorporated by NMED or are not considered, our proposed amendments aren't considered logical outgrowth, a logical outgrowth for those proposed amendments. I'm certainly not going to get into the issue of whether the merits of those contentions, that's not appropriate. but in paragraph 16, or rather 17 of Triad DOE's petition, they talk about their proposed changes and that those proposed changes are attached to their petition. Here's my question or my concern. I'd like to know which of those proposed amendments in Triad's protective petition were the subject of technical testimony, direct testimony, and opportunity for cross-examination, rebuttal, and sur-rebuttal. I think going forward, it'll really be helpful to the commission to be able to know what was presented with regard to those proposed amendments in 2116 was presented in 2051. How that gets addressed, I think, is either the prerogative of the chair, the commission as a whole, or we would certainly entertain a suggestion by the hearing officer.
So, Council Sanchez, earlier this week, I spoke to the commission's administrator, Ms. Jones, about setting up a pre-hearing conference with those parties to find out whether or not the matters were addressed in this hearing, or whether there were still outstanding issues to move forward in that rulemaking petition. So at this point, I don't know the answer to that, but we do have an email out to the parties asking for dates and times in early August to meet and discuss exactly the question you just asked.
Again, thank you for that, and that would be entirely satisfactory. My only concern is that we have some consensus or agreement since there wasn't an agreement with regard to consolidating the two proceedings. I want to be able to have a consensus from counsel of record and the hearing officer perhaps the hearing officer as to what there was an opportunity to present technical testimony, direct examination, and those similar subjects.
Okay, so are you asking me or are you asking Mr. Rose?
Well, I think it would involve, certainly Mr. Rose is welcome to tell us now which of the matters, the proposed amendments in 2116 were the subject of direct testimony, et cetera, in this proceeding. But I suspect it also may invite comment from other counsel.
Okay, Mr. Rose?
Mr. Hearing Officer, my understanding is that the proposed changes that were attached to the petition by Triad and DOE, in fact, are encompassed in Triad DOE's proposed changes in this proceeding, which are the subject of both direct and rebuttal testimony from the Lano witnesses. I'll remind the hearing officer that some of the department's witnesses made statements in their direct or rebuttal testimony concerning whether they thought that Lano's proposal was a logical outgrowth. But as far as I know, there hasn't been a motion filed to exclude that testimony. So at this point, I think they've been fully aired, and I assume the commission would decide accordingly. So we may not need to move on the separate petition, but I think until ultimately this proceeding is concluded and the commission decides whether or not it can consider Lano's proposals, I think we need to keep the petition open. But in terms of scheduling a pre-hearing, at this point, I think it's premature until we see what the commission ultimately does in terms of this proceeding. So I would expect that we will not need to move forward with that petition based on how this hearing's gone. But I think we need to, from our perspective, we need to keep that open because we don't know ultimately what the commission will decide.
Okay, Mr. Sanchez, before you say anything, let me make sure I understand Mr. Rose. So, Mr. Rose, I think what you've said is that the petition in 2116, now that you've heard all the testimony in 2051, that it fully overlaps with 2051.
That's correct.
Okay, that's number one. Number two, you mentioned something about witnesses' testimony to logical outgrowth. And I made a ruling on that already, that logical outgrowth is a legal conclusion and not a factual answer. So why doesn't that address that part of what you said?
Because it's in their direct testimony. I don't know whether they intend to argue it in their post-hearing submittals where they can raise legal issues with the commission. So until we know sort of what the next step is, I don't think we necessarily know whether everything that Landel's proposed will be considered and will be in front of the commission for decision.
And Mr. Hearing Officer, if I may, NMED may address those issues in our post-hearing brief, and I agree with Mr. Rose that we probably will need to take up the issue of his other filing, his other petition, after we finish this matter, since it has not been decided by the commission yet, and that's not going to happen anytime soon, just based on the timeline that's been set out for post-hearing matters.
Well, Ms. Maxfield, I have two concerns about that. Number one, the rules give a timeline when someone files a petition for a rulemaking. And Mr. Rose, I don't know that I have a waiver of time limits from you.
Since we filed it as a protective filing, and we understood that, to the extent to which those proposals would not be considered as part of this proceeding, that we were going to go forward. I think implicit in our request was in essence a waiver of time. I mean, the commission had in front of it our petition, but I think we reserved, an ultimate decision by the commission until this proceeding was over. So from that standpoint, I guess if you need something explicit, that's fine. We believe it's implicit in how we've addressed it in this context. And we're certainly not asking for the commission to schedule a hearing or decide the matter right now anyway. So I think the commission, and based on where they left it procedurally, is my understanding, is fine. There's a stay of proceedings, and we certainly don't object to that stay.
I'd rather have a waiver of the time in 20.1.6.200C because the rule is very clear about that. And whether it's implicit or not, let's just make it clear that there is a time waiver from your client until this commission makes final decisions on 2051. So I would like that.
And Mr. Herringhouse, we have at this point, we do waive those timelines, but I don't recall whether the commission actually delegated this hearing to you as a hearing officer. I know they did the one we're currently under, but I don't remember the procedural posture of the protective filing as to whether or not the commission actually decided on or assigned this to the hearing officer for decision. So
I think they did, Mr. Rose, because then we held a pre-hearing conference on the issue of consolidation, and I don't think I would have heard that if I was not the hearing officer appointed to that. Mr. Sanchez, do you have a recollection?
My recollection is, I was just about to pull up the order.
Oh, wonderful.
The commission entered an order appointing you as hearing officer and essentially held in abeyance the scheduling of the hearing on the rulemaking petition and left it to your discretion.
Okay. I seem to remember the same. So Mr. Rose, I would like a waiver of time to the rule that I already cited to you. But my other concern was something else that you said, which was we want to see how the commission rules on these proposed changes, this triennial review, before we decide whether we want to push on to 2116. And what I wonder about that is, if something is decided by the commission that you don't like, and that, you know, since the two issues overlap each other, or the two matters overlap each other, does that give you a right to try again?
Mr. Hearing Officer, the answer is no. In that case, the appeal would be to the Court of Appeals on the record.
Okay.
What I was referring to is the open question we discussed about the scope of this hearing and whether or not logical outgrowth, in fact, is the criteria that's appropriate for the commission's decisions. And I think, as the department's indicated, that's something they may raise in their post-hearing submittal. So ultimately, that's a commission decision. And if the commission were to decide that some of Lanel's proposals, in fact, aren't appropriate for consideration, not substantively decide, but decide as a procedural matter, not to take those up, then we might, depending on the outcome, decide to push those issues in the state matter. So it really does depend on what the commission ultimately does.
That's clear now. Thank you. I appreciate it. Were there any other issues before turning this back to Chair Stringer?
Nothing from us.
Chair Stringer?
Thank you all. That, I guess, concludes the triennial hearing. The next agenda item from our agenda is next meeting and expected upcoming matters. So currently, the next meeting would be scheduled for August 10th, 2021. And I would like to see if anyone has any upcoming matters they would like to discuss at this time.
Excuse me, Chair Stringer, are you through with me?
Well, I apologize. I thought when the hearing officer concluded the hearing, that ended the record. So sorry if I was supposed to clarify that.
I just wanted to double check. Thank you.
Thank you. Commissioner Dominguez, did you have an item to raise?
Just one of the usual questions, and that would be, part of this probably goes to Pam, is what do we have coming up in August is the first question. And then the second part of that would be for you to look in your crystal ball of when the commission may look at transitioning back to in-person or a hybrid thereof. Not to put you on the spot. Thank you, ma'am.
Chair Stringer, can I address part of what Commissioner Dominguez just brought up? Part of the August 10 agenda, or draft agenda, shall we call it, is something that Ms. Maxfield has brought and that I am appointed as a hearing officer to. Ms. Maxfield, are you there?
Yes, Mr. Hearing Officer.
Okay. There is no opposing party, is there?
There is no opposing party. This should be a relatively simple rulemaking compared to the one we've just concluded right now.
Okay. And so from your perspective, how do you, what's sort of an outline of how things will go on August 10?
I have 3 witnesses to put on. I don't expect any of them to be very lengthy, but they all have different parts of the puzzle to testify about. And as you mentioned, there are no other parties in this case besides NMED, and due to the very extensive public outreach that has been done for this case, we are not expecting very much and probably not adverse public comment.
Okay. I just wanted to know what my role would be so that Commissioner Dominguez would know what that's going to look like. But if there's nothing left then for me, I'm going to sign off. It's been a pleasure serving before the commission, and I've enjoyed this time together, and I look forward to providing a hearing officer report that helps you make a decision. So thank you.
Thank you very much, Mr. Hearing Officer. Okay, so I'm going to turn back to Pam to list any items that she's been requested to include in next month's agenda.
Thank you, Madam Chair. Other than the item that we just discussed, which is WQCC 21-26, the proposed amendments to the utility operators certification, we have Blue Water Lake TMDL to be presented, as well as Jemez River Watershed TMDL.
Thank you.
At this time, that's all we have pending on that draft agenda.
Okay, thank you. Any other items that any of the commissioners want to raise before we address Commissioner Dominguez's other question? Okay, hearing none. I would say, Commissioner Dominguez, I don't have a great answer for you as far as changing the format. I think that will be included in any public notice that comes out what we choose. We can have in-person meetings as far as I know, but there's a desire to have a hybrid format that I think we're looking into, and the administrator is seeking some guidance on that as well. So certainly the format will be clear in the public notice for the meetings, but I wouldn't say that I know exactly what that looks like at this time. Hey, are there any other items that need to be discussed before we adjourn the meeting? Okay, this was a really long and intense proceeding divided over the 2 weeks. So I really appreciate everyone's attention to the matter and their patience in getting through all of it and all of the parties. So thank you very much. And with that, I will adjourn the meeting until the next time. Hey, Pam.